Good day, everyone. I am Pamela B. Acosta.
Hi, and I am Ms. Michaela here, and we are going to discuss about Article 39, the new Civil Code, the incapacity to act of insolvency. Ms. Acosta?
Okay, first, let me define what is insolvency. Based on Section 4 of the Republic Act number 10142, also known as Financial Rehabilitation and Insolvency Act of 2010. Insolvent shall refer to the financial condition of a debtor that is generally unable to pay its or his liabilities as they fall due in the ordinary course of business or has liabilities that are greater than its or his assets. So insolvency means that if a person has a loan and the person cannot pay in its due date or deadline of his or her payment is considered as an insolvent person, or if the person has a liability more than his or her assets. For example, so let's liquidate the asset of person A. So person A has a 20,000 pesos in cash and also a house worth 300,000, a car worth 200,000, and a furniture worth 50,000. And in the total of 570,000, while his liabilities worth 500,000 in his bank loan because of his gambling, and a credit card loan worth 200,000 with a total of 700,000. Person A considered as insolvent person because, as you can see, his liabilities are greater than in his assets. So the remaining balance of his liabilities, person A cannot pay it because of the insufficiency of his assets. That's all.
Based on the example, if there will be an offense, for example, if an owner, partner, director, officer, or other employee of the debtor who having knowledge, belief of any person having provided a false claim against the debtor, fail to disclose the same to rehabilitation, receive of liquidation within 1 month after coming to said knowledge or belief, or if he shall knowingly violate a prohibition or knowingly fail to undertake an obligation established by RA number 10142, there will be a penalty under Section 145 of the same Act. Going to the next slide, please. Section 134, order removing the debtor from the list registered entity titles at the Security and Exchange Commission. Upon the determining the liquidation has been completed and according to this act and applicable law, the court shall issue an order approving the report and ordering the SEC to remove the debtor from registry of legal entitles. For example, let's have a case. On April 1, 2014, under the Mortgage Trust Indenture or MTI, KD Bus Company Incorporation granted a loan of 1 billion pesos to PA Bank secured by a mortgage of 10 brand new buses and a 1.25 billion pesos to MT Bank secured by a mortgage of 11 brand new buses. On September 2, 2020, KD Buses Company Incorporation had an assets worth 234 million pesos and the liabilities worth of 1.234 billion pesos. On October 3, 2020, KD Bus Company Incorporation default in paying its loan to PA Bank and MT Bank. KD Bus Company Incorporation filed for a renewal to Securities and Exchange Commission or SEC. Let's go back to the topic earlier. What will happen to the request of renewal? The SEC will docket it and will transmit to the court for its approval because as what we have said earlier under section 134, the SEC does not have an authority of power to remove the debtor in the registration in his own. There shall have an order coming from the court removing the debtor from the list of registered entitles at the Security and Exchange Commission. Going back to the example, KD Bus Company filed for a renewal to SEC. SEC denied the renewal. Due to sudden non-renewal and massive withdrawal for creditors of their loans to KD Bus Company Incorporation, severe drop in the sale of bus transportation and decrease investors. KD Bus Company filed a voluntary liquidation. Then for the example na po.
Okay, thank you for your listening. We hope that you gain more knowledge about insolvency.
Thank you.